Good evening, ladies and gentlemen, members, and welcome to the July meeting of the Borough Council's Planning Committee. I am Councillor Smith and I am the chairman of the committee. Other members and officers have their names in front of them for ease of reference. I will take a few minutes to explain the process we work to in these committees. Each application will be presented by the appropriate case officer. After each presentation, those members of the public who have written to the council requesting to speak will be invited to the seat at the opposite end of the table. The time allocation is 3 minutes for each speaker. This will be strictly timed and enforced. Speeches must relate to material planning issues and must not be derogatory. No questioning is allowed and no further written information, photographs, plans or other material can be submitted at this stage. Those applications on the agenda with public speakers will be dealt with first. So the running order for tonight is, as is the agenda, with 55 Hillside first and then the Quants second. I hope this is clear. If there are any questions, please speak to the officers, me after the meeting. If the meeting extends beyond 9 PM, I shall ask for a proposal for the members to extend the meeting to a specific time. Once the item under discussion at the time is resolved, the meeting will then be adjourned and will reconvene on another evening. In order to assist in the process this evening, I must ask everyone to ensure that mobile phones are either switched off or on silent mode. We would be grateful if you would remain quiet whilst the meeting is in progress. I would like to remind everyone present that this meeting will be filmed by the council and broadcast live on the internet and will be capable of repeated viewing. If you are seated in the chamber, it is possible that the cameras will capture your image. By your presence, you are deemed to consent to be filmed and to the use of these images and sound recordings for webcasting and/or training purposes. As the chairman of the meeting, I can, at my discretion, terminate or suspend filming if, in my opinion, continuing to do so would prejudice the proceedings of the meeting, or if I consider that continued filming might infringe the rights of any individual or breach any statutory provision. There are no planned fire alarms this evening, so if the alarm does go off, there's a fire exit at the far left there, or back through the door through which you came. We will now move on to the agenda. Agenda item, apologies for absence.
Yes, Chairman, I have apologies from Councillor Fox and Councillor Hall. Thank you.
Thank you. Do we have any declarations of interest? No declarations of interest. Go on to number 3, the minutes. Do I have a proposer for the minutes from the previous meeting? Thank you, Councillor Neer. Thank you, Councillor Bath. All those in favour of the minutes? That's unanimous. And we then go on to item 4A, 55 Hillside Drive.
Thank you, Chair. Before doing the presentation, Chair, I'd like to just draw members' attention to the update sheet, and hopefully I'll be able to make this work. No. That's better. Members, you'll see from the update sheet that, and I'll just read this out for the benefit of the public gallery, following the completion of the committee report, the applicant contacted the authority to offer a unilateral undertaking to secure that the property remains a single dwelling house. So as we stated in paragraph 8.8 in the committee report, a suitable legal agreement ensuring the building remains as a single dwelling would overcome our objections to the scheme. So in the circumstances, as officers, we're prepared to amend the recommendation to one of approval subject to the completion of a suitable unilateral undertaking and with the conditions listed in the update. And then if the agreement is not concluded within a suitable timeframe of 2 months, that the application be refused for the reasons set out in the report. Just to add to that, Chair, I just want to draw your attention to condition 5, and the reason for seeking to impose condition 5 regarding the completion of the internal works was simply to ensure that the development on site was in accordance with the approved plans, because it would be unhelpful for the applicant to have a permission which the works internally don't correspond with, because in effect they would still have an outstanding issue with regard to the lawfulness of the works. I'm advised by the applicants of the difficulty in actual fact of implementing what's shown on the proposed ground floor plan for the reasons that we've set out in paragraph 2.4, which is in relation to where the services are, the gas meters and the existing staircase. We would, as officers, be content to strike out condition 5 because from our point of view, the unilateral undertaking covers the issue of keeping the property as a single dwelling house. So I would, as part of the recommendation, take out condition 5. But I'll just move on to the subject to receipt of an amended plan that actually accurately reflects the works that have been undertaken in the property. But hopefully it'll be a little more clearer as I just go into the presentation, Chair. So the scheme before you is to vary condition 2, which relates to the approved plans of the original permission back from 2017, and condition 4, which relates to installing windows in the side elevations of the roof space. So this is the location of the property here, and shown on the aerial photo here prior to the works taking place. This is the red line of the site, shows the whole of the application site around the dwelling house. These are the plans which were approved on the 2017 application. And just to draw your attention to, at the time, the consent that we approved included the staircase in this location here and within the middle of the property. And as you'll see when you upstairs, the existing layout here with the kitchen diner area and the main dining living space here. These are the elevations as approved back in the 2017 application, and these works externally are now largely complete. You'll see reference in the report and the planning history to a non-material amendment that was submitted, and this sought to gain approval for an additional roof light that had been added here and a side door on here. And we just want to clarify for members' benefit the difference between considering a non-material amendment application where we're concerned with a technical assessment as to whether the changes are materially different from the planning permission that's been granted already, and the application before you currently, which is an assessment of the merits of what's been proposed and built. So just to highlight the changes that have been made, so this additional door in here and this additional roof light here, just to correct an error in the report, apologies for this, at para 2.22 we have said the roof light's above a kitchen, but it is actually above the bathroom of the property. And so just to do, so you can do a comparison, these on here was the floor plan as approved, and this is the currently proposed floor plan. Now when I was talking about condition 5 on the update, Chair, it was in relation to this door here. So this door is shown on the proposed plans but has not been constructed on the site itself. And as it stands, my understanding is the staircase comes down here and the utility boxes are all in this area here. So there would be a significant technical difficulty in effect in delivering that proposed plan. And then just to show you the differences upstairs, so whereas originally what was approved was the staircase coming up centrally, what you've got is coming up on this corner here, and that's necessitated this change in the layout here, where it's a sitting room and a kitchen is over this side of the building, and then this is where the additional Velux window has been added to the bathroom, which is an obscure glaze opening. And just lastly, some photos of the site. So these are the works as constructed. The door chair is on the side here. This is the roof light which has been added, which is in the approved position on the kitchen, and this is the new roof light added to the bathroom. Both of these are obscure glaze, and just this little sort of white cylinder you can see here, these are restrictors which prevent the windows being opened any more than there are shown on the photos, Chair, so they can't be opened any further to look out from. So apologies, it's slightly complex in terms of the recommendation, but we recommend the application be deferred to the head of planning for us to approve, subject to the completion of a suitable unilateral undertaking and with the omission of condition 5 for the reasons that I have given, and the submission of a suitable amended plan to accurately show the works undertaken within the building.
Thank you. We're now going to go to our public speakers, and we're going to take the speaker against the application first. So if Mrs. Hurl could come to the table. If you take a seat and make yourself comfortable, introduce yourself, and then we'll start the clock after you've introduced yourself.
Thank you. Good evening. My name is Mary Hurl. I live in Hillside Drive, and I live opposite 55. And as Councillor Smith has said, I was one of the original objectors to the self-contained unit being put as such on 55. Thank you. Does it stop? Okay, well, what I have to say first of all, I have to talk quickly because I had no knowledge of this till I walked in the door this evening. So until I came here, I was under the impression that the council were minded, I know that's not prejudging your decisions today, to refuse as per the original plans, because they clearly stated in 2017 that the stairs had to be sited in the house. There would be no independent access because it is formally a self-contained unit. And I'm not clear, and it's, you know, I haven't got enough time to go through this, but if I could quickly ask, you talk about a legal agreement, but I don't understand what are the terms of this legal agreement, please. And more to the point, we don't know who will enforce this takes place for the duration, not just for now. Who is going to enforce that the legal agreement stays in place for the property if it changes owners or goes forward? And I can only say, looking at this history of 55 and basically history of non-compliance with the planning rules, who will make sure that the legal agreement is complied with? Because I know you don't have the staffing, I was told before, to follow up. This says it has to be done, whatever. Basically, and I'm not sure if the outside door is going on the side. Do I take it, I can ask, that is still staying? Because, as you said, number 5, the door's not going to be done internally, and it was said at 2.4 in the original plan that it's undoable anyway. So I'm assuming that the outside door is staying, but that's not clear. And when you talk about approved plans, I'm not sure whether you mean, because I think the approved plans are the ones in 2017, which approved access through the main front door and stairs centrally. So I'm not entirely sure when you talk about approved plans what you mean. And also obscure glazing, if I could also ask, because an extra window has been put in on the left-hand side, giving privacy issues still to the neighbours on that side. They're not able to be here. So I don't know what you mean when you say obscure glazing and no additional openings. Is that no additional openings in a place to the additional one they've already done? Or is this no more on top of the one they've already done? That's not clear. And the rest is just, as you say, doing outside or whatever, and the drive. I don't know what you mean by turning and parking, because there's no room to turn on the drive. It's got parking for 5 vehicles, which it has. So, but I am very concerned how you will ensure going forward, because I know you don't have time to come and show. This is what happened with the original plan. You, the council, agreed to set plans, and a completely different thing, a completely set a plan was implemented. And when I phoned up, I was told you don't have the manpower fair enough to police it, for want of a better word. So how will we know what's going to happen? And if they're still coming in the back way, and there's a door to the back of the garage anyway, which is a utility room, so there is still a self-contained unit, and I just wonder how you're going to make sure it's not used as such going forward. It's a worry. It's a special area. I've lived there for many years, and I want it to stay a special area. Thank you for your time.
Thank you very much. And our next speaker, who is for the application, is Mr. Finn. Again, if you'd like to take a seat and then introduce yourself, and then we will start the clock.
Good evening, Madam Chair, members of the committee. My name is Lionel Finn. I'm a consultant solicitor with Lacey's, who represent the applicant in this case. You ready for me to start? I'd like to begin, if I may, Madam Chair, by assuring the committee, in answer to the previous objection, that the unilateral undertaking, which has been drafted and has been submitted, is a very enforceable document, giving the council more powers indeed than an ordinary planning condition, and it will remain in force indefinitely. It's very difficult to change a Section 106 agreement, which this is. And the proposal is not in any way to risk having two separate units here. There's a daughter who is a mature daughter of the applicant, who is married and who lives upstairs, and downstairs the mother, who's the applicant, lives with her partner. And the whole object of the layout, as you see it, is to provide normal privacy to two separate families. It's not like a mother and young daughter who are living together. They are now both with their partners and therefore need a degree of privacy, but apart from that are very happy to live together in the one unit, and that's what it will remain. And the unilateral undertaking will provide for that. And the only reason 2 months is asked for the agreement of it is because there's a mortgage and the bank have to be a signatory. And as many of you will know, you can't get a signature from the bank simply by asking for it. It takes time. And that's why we've asked for the period of 2 months. But apart from the bank, we would have been ready to sign it for today. So as far as the plans are concerned, the idea is that everything should stay as it is. And as your officer has described, the problem with the connecting door has gone away into the lobby. It's not proposed to proceed with that, so everything remains as it is. And yes, the external door will remain because that will give the privacy of a separate access to the upstairs. And that is part of the revised application, which is my understanding you are going to be asked to approve, subject to the unilateral undertaking. Thank you very much.
Thank you. Did our legal officer want to come in at this point?
Yes, thank you, Chair. Just picking up on some of the original concerns of the original speaker, I think it's fair to say that the solicitor for the applicant has made the points quite eloquently, in the sense that a Section 106 planning obligation will bind those entering into the obligation. So it will be the individual signatories to the deed, but it will also run with the land. So anyone deriving title, so any forward purchaser, will also be bound by that obligation. So it controls the actual unit in rem, that is to say in law. Anyone who takes title will still be bound by that, rather than what we say in personam, in person. So it's not actually just binding the applicant and the signatories, it's binding the site throughout. That's the first point. The second point is that any breach of a planning obligation is a more serious breach, if you like, than a breach of condition. So we have powers to serve breach of condition notices. That can be served. That calls for a period of time to be complied with. If you don't comply with that notice, you then become prosecutable. You can be prosecuted for breach. But with a planning obligation, a Section 106 obligation, that obligation, if breached, is enforceable by an injunction. So that is ordinarily a High Court matter. We would ask for an injunction. That injunction will stop the breach. And then if there's a breach of any injunction and it's not stopped, that becomes a contempt. And a contempt is imprisonable. So actually the use of a planning obligation is a strong tool. It binds the land, not only those entering into the original deed, it will bind it forwards, the particular site, any purchaser, anyone deriving title. Also, there's more teeth in the sense that an injunction is the remedy to any breach of a planning obligation. And as I've mentioned, that has sanctions. Contempt of court, if you fly in the face of a court order, then the courts do not like it. Woe betide anyone who defies a High Court judge. So with respect to the applicant and the solicitor there, what Mr. Lacey has made the point, it is a strong tool, it is a strong mechanism. So it's not something that perhaps the applicant would offer lightly. I would hope that those obviously advising, taking instructions from the applicant would understand the obligation that they're entering into. It is a fierce obligation, and we have enforced 106 breaches. So any breach, if this becomes a separate dwelling house, and if someone lives next door, neighbours, yes, we've got a small enforcement team like all councils, but where do we get our intelligence from? The community, those who live next door. That's what we rely upon. So any inkling of a separate residential unit will be a breach of that notice. And trust me, I'm employed to do a planning job. So if there is evidence of a breach, it will be enforced. That's a simple fact. There's another option too. We can serve an enforcement notice. So we have the powers to serve an enforcement notice because obviously a separate dwelling house has now been built without planning permission. We have a choice. We can go for a Section 106 breach, or we can serve an enforcement notice. An enforcement notice will also bite, and that has to be complied with. If not, that then becomes a prosecutable offence. Not only in terms of the magistrates' court, it becomes a triable either way offence, a Crown Court matter. So a summary only offence for breach is a £20,000 fine in the magistrates. In the Crown Court, it's unlimited. So there are strong sanctions in the sense of not only the Section 106 obligation to protect that this isn't a separate dwelling house, but we also have other powers, and that's an enforcement notice. So to cure, if you like, the defect here, in the sense that it's next to the SPA, within 400 metres, Natural England raised the proper and prudent objection here to, if you like, overcome the policy objection, that is to say, no further dwelling houses within that period of control. The applicant has offered this obligation to say, that's not our intent. Our intent here is to afford privacy for a household only, one household. It's not a separate dwelling house. That overcomes Natural England's policy objection. It therefore, if you like, is not contrary to policy in the sense of protecting the natural environment. That obligation overcomes that reason for refusal. So that's how it works. That's the mechanism. There's nothing untoward in the use of a Section 106. These are nothing new, councillors. This is being offered by the applicant. The applicant has been obviously advised, and it overcomes a policy objection. Unless I can be of any further help.
That certainly helped me greatly. Yes, if you could pick up the other points, that'd be fine.
Yes, Chair. Just for members' benefits, you did hear from the objector about the issues of the openings in the roof. And just to clarify that the condition 2 shown on your update sheet has a twofold purpose. Firstly, it's to ensure that the side-facing openings in the roof are obscure glazed and stay that way. And then secondly, that no more openings can be inserted into those side elevations without gaining a further planning permission from the council. And that's a repeat of a condition imposed on the original permission. Yes, and just to confirm that this plan on the right hand side is a plan that was approved back in 2017, and then this is the currently proposed plan, but as I say, just for clarification, this opening here has not been formed, and as the works are largely complete within the building itself, the applicant does not intend to insert this particular door, and they are proposing to give the council a proposed floor plan which accurately reflects the internal layout of the building. And just to clarify that our reason for refusal is solely based in relation to the possibility of the creation of a separate dwelling house within the 400 metre zone of the heathlands, and that's our prime concern with this particular scheme, and it is the creation of, and the objection that we've had from Natural England, and the creation of an independent dwelling house, which would be the substance of any objection on this particular site.
Thank you. Going to go to questions now. Councillor Grace, you were first.
Can I just ask you, so with the stairs, is there any access from the ground floor to the top floor through the house, or is it only access from the outside? Thank you, Chairman.
Chair, this is actually internally, so it is inside the building, but no, there is no access from this part of the dwelling apart from through this back door into this area here, and then the only way to access the upstairs is to come in through this door here or the back door and then up the stairs.
Any further questions? Councillor Barr.
I'm probably stating a bit of the obvious, but it seems to me that the only difference between this being a separate dwelling and not being a separate dwelling is that the people are related, but they're living separately. And I guess it's a matter of law that as long as it can't be sold on as two separate dwellings, then it can be occupied as a single dwelling. But it does seem strange that to mitigate the additional use of an area by stopping dwellings becoming two, but it's allowed if those people happen to be relatives living within one building but living separately as two separate homes. Just wondered if there's any clarification on that, what the difference is really.
Thank you, Councillor. Yes, through you, Chair. It's a complex area of law, and as one would expect, it's governed by case law, and I'm sorry, I don't have the time to trot you through the case law as to what is a separate dwelling house, single household or multiple households. Rest assured it can be achieved, and one would hope the drafting coming forwards from the applicant's legal advisors would appropriately take on board, if you like, the case law as to what is a separate dwelling house. In that sense, I think it's in the gift of the applicant here, where it is one family, one household, that probably achieves what is required in law to say this is one planning unit, one household. It's the same relatives, one household, all under one roof. It's just privacy concerns. However, the drafting coming forwards and the recommendation as proposed now protects you, councillors, in the sense that you'll be delegating to the head of planning, so that when the draft comes forwards, we can necessarily advise the planning department about whether or not that achieves what the applicant wants and what the local planning authority wants to retain control. It's a question of, if you like, working with the applicant's solicitors, looking at that particular draft and saying it's acceptable or not. Where it's a unilateral, the council will not be a signatory to this. Okay, so the drafting could come forwards, they could execute that unilateral and say, if you like, that is it. And where the council is not a party to it, if it's not acceptable still to the council, then obviously the recommendation protects you still, in the sense that the contra is that if it's not acceptable, then the refusal will follow. So there is, if you like, to delegate to the head of planning to have sight of the Section 106 agreement. If it's good, bounce and braces, secures good development control going forwards, permission will be granted, subject to your resolution. If it's not good and it's been executed and we're not happy with it still, then the head of planning is obviously delegated by your powers to obviously forward a refusal. So I can't answer your question. I haven't had sight of the drafting, I'm afraid, but rest assured, the legal advisors, myself, and obviously being a barrister, non-practicing, I will look at that point. So I can look at all the case law and say it achieves it, yes, or no, it doesn't, and work with the applicant solicitors. Does that help? It's the best I can do, I think.
Councillor Nottage.
Thank you, Chairman. I'm interested in the comments that were made, 7.2, Natural England. Appreciate the close proximity, etc., of SSI. I understand that. But the plans, they say the plans show 2 dwellings each with a separate entrance. Well, that doesn't appear to have changed. I haven't seen a statement from Natural England which actually confirms that they are quite happy to accept the situation as you've described. Does that exist?
Natural England's concern is the formation of 2 separate entities, 2 separate units of accommodation. If we have a legal document that retains it as one dwelling unit, then Natural England have no grounds to object to it. So we haven't gone back to them. We don't need to go back to them. We don't need their sign-off that a legal agreement achieves that, because as Mr. Lucas has explained to you, the legal position is, through the legal agreement, that it will remain as one unit.
So, for clarification, the objection from Natural England was said the plans show 2 dwellings, each with its own separate entrance. That's their objection, and you're saying that Natural England will remove that, despite the fact that we appear to have 2 separate entrances.
I think bullet point 3 may clarify it slightly on Natural England's objection, where they say that the proposal substantially increases the risk, but it doesn't say that that is an absolute risk.
Sorry, Mr. Chairman, Madam Chairman. The consultations here, presumably we take consultations from Natural England quite seriously. It says quite clearly the plans show 2 dwellings, each with its own separate entrance. We now have 1 dwelling with 2 separate entrances. And are we saying that Natural England are quite happy to accept that situation? Or are you saying that you don't have to bother to talk to them?
I've got Natural England's full comments in front of me now, which says that the proposed plan showed 2 dwellings within the building, each with their own separate entrance, which is not unusual for a building to have 2 separate entrances. And I think the key thing here is no internal access from one to the other. Now, on your update sheet tonight, the proposed plans show here an internal link which gives integration between the 2 units. And until just before this meeting, officers were of the opinion that
is shown on the proposed plans, that could be delivered. We've since subsequently, just before starting the meeting, been advised that really can't be achieved. So as officers, we're in a bit of a tricky situation, a bit of an unusual situation here, in that we were satisfied there could be integration as shown on the proposed plan. We're now told that can't be achieved, and unusually I'm going to suggest that this is a matter that needs further consideration, further discussion with the applicant to assess whether or not there can be integration between the two, and I would suggest that members consider deferring this item to give us the opportunity to further explore that, because I'd just like to clarify that other than the 400 metres, which could be overcome by the legal agreement, if, in my opinion, if there were some integration, there are no other planning objections to the formation of 2 units on this site. There's no planning objections, otherwise you would have had more than the one reason for refusal in front of you tonight. So I'm sorry to do this, and it's very unusual, but that is something I would suggest the committee consider doing.
Councillor Loss, you had a question. Is it relevant to the information we've just received? Based.
I was really going to ask the question, why are we looking at this at this time? And as you know, I might find it different, but I was second Casey to say my complete support for the head of planning institute.
Is that a proposal, Councillor Lofts?
I'm happy to make a proposal, whether anybody wants to second it.
I think I have a seconder in Councillor Neil. I think in the circumstances, I think yes, with the added information and the fact that we can't make it a single dwelling with an integral door, that we do need to go back and get some more information. So I'm going to put that proposal to the vote. All those in favour of deferral, and I will vote. All those. Okay, well, we'll go to the debate about deferral then. We have a proposer and a seconder on the table. Does anybody else wish to speak about deferral? Of course, Councillor Neil.
My view is that now the internal door is not being delivered, you have to go out of each building to get into the other one. And in my view, that makes it 2 buildings. And I fully understand how Natural England have come to that conclusion. The amended plan has got a door there, but it does need to have some access to both parts of the building, otherwise it is 2 buildings.
Councillor Nottage.
I concur with the councillor. It just seems very odd. I think what you're asking us to do is to pass a planning permission with legal conditions, giving the head of planning options to include for an internal door or not include for an internal door. I don't think that's planning. I don't see it. I think this is a hugely complicated issue.
That's not what we're debating. We're debating whether to defer the item so that we
Well,
can get more information.
Chairman, what I said was that to the end of my statement that we are now offering a deferment with the referring to the head of planning being able to decide whether or not to have a door internal or what.
No, that's not what the deferral's about. If it's deferred, then it will come back to committee for us to decide once we have additional information regarding the door. No, they will not be going away with planning permission this evening. Do I have anybody else who wishes to speak?
May I speak on the deferment?
Thank you, Madam Chairman, and thank you, Mr. Lucas, and also to Jane, Mrs. Lynch. All I wanted to clarify, in view of the comments that Councillor Nottage has made, that my request for referral will still stand following the deferment, so that it will come back, and I promise to be on time.
That will be minuted, and because it is deferred, it has to come back to us. There is no other route for it. So on that, I'm going to go for a vote on the deferral. All those in favour, please show, and I will vote. That's 8. That is approved. This item will be deferred, bearing more information on the door. And we now move on to item 4B, the quants.
Thank you, Chair. Next item is this application. This comes to you because it's works done by the authority and to site light colours to install a CCTV aerial down at the Quants. This is the site here. It's directly opposite the splash park on the little grass verge next to the harbour side there, quayside. Just the aerial photo here. So the lamppost will be going in just on here. And just to show you a little bit more detail of the location. In the application, it states that the proposed light column will match these existing ones in colour design. The only difference is these, I understand, are 5 metres high, and the one which will be installed just over here will be 6 metres high, so it'll be slightly higher. This is show the precise location. It was obviously before we had the drought, because this is the site now, where it obviously hasn't rained in the interim. But it would just go with this location here, and then looking back from the side to looking towards the Priory. Chair, this is for us a very straightforward application. It does fall within a number of particular constraints, such as the conservation area and I'm surprised to learn the green belt there, but for us it's a piece of essential infrastructure which will support the council's CCTV service, and in particular the relaying of the information from the various cameras across the borough, and it just picks up a little dead spot in their current coverage. We feel it has limited impact on the wider character and use of the area, and consistent with the overall appearance of the conservation area, subject to the use of a matching design as shown there. And therefore because I understand there's a degree of urgency from Mr. Whitney's department to install the works, we've taken this to you a little bit earlier than we would normally, but we recommend that the application be deferred to the Head of Planning to approve following the expiring of the consultation period. And in that regard, we note we haven't received any objections to date and have only received letters of support.
If you'd like to refer to your update sheet, there is a quick mention from the Council's Conservation Officer.
Yes, apologies, Chair. Just to confirm, the Conservation Officer has now finished their formal comments and confirmed their full support for the scheme.
Do we have any questions on this subject? Councillor Nottage. We're in questions, not debate. Councillor Spittle.
Chair, the test for us would be whether there would be any residential development properties adversely affected by that. And just to show you, reason for putting the aerial photo up was just to indicate the distance away to the nearest residential properties over in Wick Lane. And at that distance, we would be satisfied there wouldn't be any particular light pollution to those residents.
By putting this column up, is it going to make that area safer?
The purpose of it is to support the existing CCTV camera network. So what it does is it relays signals that have been sent from elsewhere. So it's not a camera itself. What it's doing is relaying signals from elsewhere because there's a dead spot, as I understand it, in the existing reception and relaying of information. So allow that information to go over quicker to the central hub where the information is monitored. So that's the reason for it.
Councillor Lofts.
Are the words included in 8.10 the views of the planning officer, or have our flood defence people been asked for their opinion?
Chair, no. The short answer to your question is no. But what we're not doing is constructing a building where we would be putting assets, what the Environment Agency would describe as assets at risk, i.e. people, which could be affected in the event of a flood. So the ground take of the post is that. So in the event of a flood, the amount that displaces is nominal and doesn't affect any wider assets at risk like people's houses or any office buildings or public buildings. So that would be the reason for not needing to go to the Environment Agency in this particular instance. It's just normal infrastructure. Chair, just there aren't officers within this local authority responsible for flood risk issues. So where you have an application that may be affected by river flooding, fluvial flooding, the Environment Agency are a consultee. Where you have an issue with surface water drainage or non-main rivers, Dorset County Council currently are the drainage authority, and there are protocols for consulting with DCC, and they are only on major planning applications, so more than 10 units plus 1,000 square metres or a size over 1 hectare in size. So it isn't a requirement on this particular minor application.
Do I have any further questions? Councillor Neal.
We might as well ask this question. It is very, very near the children's play area. Has it been actually assessed that that's the nearest or best position for it? Because there are a number of people that have fears of infrared and the rays from CCTV electrical currents.
Chair, my understanding is the location is driven by the need to secure the best signal for the aerial. In relation to the health risks, our understanding is, whilst concerns have been raised in the past, there is no established evidence of health risks from such installations, and bearing in mind the length of time such things as these infrared and mobile phone masts have been in existence, I think if there was a substantial health risk apparent, it would be becoming more obvious by now.
Any further questions? In that case, we'll go to debate, and Councillor Nottage. Councillor Grates, my apologies, I should have come to you first.
Thank you. Through you, Chairman, I'd like to second, and I agree with everything that Councillor Nottage has said, and I think it will be brilliant for us to have that CTV camera there. Thank you.
Do I have any more debate? In that case, we will go to the vote. This application has been proposed and seconded to be approved. All those in favour? That's unanimous. That application is approved. And I do believe I can now close the meeting.